All right, good evening, folks. Welcome to Monday Night Law here at Kirk's Law Corner. This is April 29th, 2024. Hope everybody had a wonderful weekend, a good week. Diesel D's, good to see you, brother. Who's your back eye? There you go. Yep. I know. It's been pretty crazy. So did everybody see that what I posted out there? The House did their impeachment vote. So on over to the Senate. It was kind of weird, but I listened in on that even after they did the vote, and they still continued on with presenting things, and it's like, yep, we all know, just present the evidence. But the reality here is, how do you impeach somebody who's already deceased? How does somebody act as president when they're deceased? I mean, if we're going to tell the truth, right? I don't understand how this is all working, how this is all being played out. It's like, why are they even attempting to impeach Biden? Let's say even if he was alive. Let's go with that. We're coming down to the end, right? The end of this alleged presidential term. I don't know. I just don't quite get it. Hi, James, out there on YouTube. Good to see you, brother. Diesel for We the People News. All right. Well, thank you. I love watching my stuff and learning. Yeah, Shannon, that's where I was going. Why are they doing this? It's for optics, right? I mean, technically speaking, I guess there's what? How many more months do we have left? Let's see. This is April. Well, April's about gone. So you got May, June, July, August, September, October, November, December, January. Got about 9 months. So I don't know. Well, again, I want to remind people that again, we are under a two federal directives by the military, okay, for a continuity of government. And I don't know how many people really comprehend what a continuity of government means. It means when there's essentially like a catastrophe happens, and let's say it takes out part of the government officials. They're just wiped out. They're dead. Volcano, earthquake, water wave, tsunami, those kinds of things that are actually considered a natural catastrophe, have nothing to do with communicable disease. Hi, Jax. Good to see you. The thing is what a continuity of government is designed to do is to bring in new people to continue carrying on, essentially like a government interim. And in a way, if we look at this and we apply this to what's really been happening especially with Executive Order 13818, blocking the property of those involved in serious human rights abuse and corruption. Okay, we're talking about taking down corrupt governmental regimes worldwide. Okay, this is from December 20th, 2017. So we think of that in the sense of a continuity of government. If they're coming in and taking out entire governmental regimes, now in our form of government, and what this is designed to do again is to have this interim government. They have certain select people that are really doing, taking care of governmental affairs. And in a way, I guess not really in a way, but the truth is it is martial law. Okay? It's not the scary martial law, what a lot of people think of what meaning by martial law is, where the military is literally standing out here on the streets and controlling everything. A serious military presence. That is martial law as well. But under the continuity of government, it's still martial law. Just in the sense of they're slowly taking these people out using military operations worldwide, right? Because a lot of the corruption and stuff, money, funding, and all that stuff, for those of you who didn't know, really came out of the Vatican. Has been for a very, 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 very long time. Even with the Sestake Trust Act of 1666. But the Vatican's been around much longer than that. So, Brother Mark, good to see you. Karen, Jax, I did not hear that 3 marshals were shot and killed in North Carolina. That's crazy. Yeah. Well, how does 3 U.S. marshals get shot in North Carolina if there isn't something going on? Now, we all know that, or at least I'm aware of, and I've shared it with you folks, essentially, the U.S. Marshals have been actively engaged in making arrests here in America based on indictments that are being unsealed essentially since September of 2020. So we're coming up on 4 years that the U.S. Marshals have been executing these essentially warrants from unsealed indictments. Joy, you didn't either, and you lived there. I know, right? Again, this, essentially military operations. Typically, they are in and out, real quiet, and especially when we're using U.S. Marshals now. That's the civil power. See, the military is supposed to be subordinate to the civil power. Now, we can use military on foreign soil, technically speaking, which is precisely what we look at what happened on January 20th there, or just after, January 6th, where the military came in and put up those, 3 layers of fencing. And if we look at the Law of War Manual, that 11.2 and 11.3 there, about foreign occupied territory. Now, I've explained it like this before, is that, that particular election cycle, they were given the opportunity to do the right thing. And they didn't. They had a choice to, throw in their cards and say, okay, we're busted, we're done. Nope. They just didn't want to do it. And like Trump said, that he had a very difficult decision to make, and that this was much bigger than they thought. Now, in my mind, what he meant by much bigger than they thought was how deep underground tunneling and all this stuff, and the magnitude of the amount of people worldwide that are involved, including basically all of Hollywood. I don't know about the rest of you, but there's some people that I, in a sense, genuinely liked as actors. I'm just disappointed, bummed out a little bit that most of these people are involved in, satanic rituals and selling their souls, uh, eating babies, child trafficking. It just blows my mind that, again, like most of Hollywood, but it's even bigger than that, right? So, well, okay, there's a question out here. Disabled Outcast on YouTube. Do I ever cover civil rights law, the ADA, the RA, and the FHA? What we need to comprehend here is our rights don't come from the Constitution. We're talking about uh, like laws of nature. And get back to these three basic, primary, absolute rights: the right of personal security, the right of personal liberty, and the right of private property. Okay? And it's in the Declaration of Independence, right? Life, liberty, pursuit of happiness. That's what those three rights really are about, is the laws of nature, as the Declaration of Independence lays out, to assume the powers of the earth and the laws of nature, and of nature's God. And that among these unalienable rights is life, liberty, and pursuit of happiness. And that to secure those rights, governments are instituted. So I personally, working on my Title 42, 1983, getting ready to file it, and in reading Title 42 of the United States Code, subsection 1983, it says in there that it's a suit at law. That's the common law, suit at common law. In fact, let me pull that sucker up here real quick because I'll just show you. Even though they call them civil rights, the Civil Rights Act, well, that includes, and I'll let me see if I can get to this here real quick. And then I'll pull it over here and show you what this is really about, All right. So here's your Title 42, United States Code. It's all code, see? And we go down here to 1900. Should be 1900 through 2000, 1981 through there it is. The civil rights. And we look at 1983, civil action for deprivation of rights. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory of the District of Columbia subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof the deprivation of any rights secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress, except that any action brought against a judicial officer for an act or mission taken in such officer's judicial capacity. Injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. Now, when we read, where was it? Prosecution, 1988. Proceedings in vindication of civil rights. Applicability of statutory and common law. Imagine that common law is what this is. Essentially, Title 42, 1983 really is a suit at common law. That's what it said in there, suit at law. And when we talk about at law and not in law is incorporated. That's under Article 3. Suits at common law is Article the 7th of the Bill of Rights, 7th Amendment. Suits at common law. But see, we no longer have the people's courts with justices of the peace and doing suits at common law. So where there's a right, they have to provide this remedy. And interesting enough about this right here in the vindication of violation of rights, the jurisdiction of civil and criminal matters conferred on the district courts the provisions of revised statutes of protection of all persons and their civil rights, and for their vindication shall be exercised and enforced in conformity with the laws of the United States so far as such laws are suitable to carry in the same effect. And that's what this is supposed to do, right? Because again, they took away our common law courts. They took away the powers of the people. But in all cases where they're not adapted to the object or subject, or are deficient in the provisions necessary to furnish suitable remedies and punish offenses against law, the common law, as modified and changed by the Constitution and statutes of the state wherein the court having jurisdiction of such civil or criminal cause is held, so far as the same is not inconsistent with the Constitution and laws of the United States, shall be extended to and govern the said courts in the trial and disposition of the cause, and if it is of a criminal nature, in the infliction of punishment on the party found guilty. So, again, I mean, clearly we can do criminal in nature as well, and make no mistake, I'm going to be forcing that showdown. Plain and simple. Cannot sit here and deny suits at common law when it's the 7th Amendment and the rules of the common law. Not your statutes and not your shit made up rules of procedure. Okay? Common law is a jurisdiction, a body of law. It has its own rules, like maxims of law. Right, Mark? That's the real law. Because, see, even the Constitution itself, law of the land, is it's common law of the land. Let's see. Wow. No, I haven't seen that one. Leslie over here on Telegram. We see the bishop in Australia who got stabbed on the pulpit for speaking about the evil of Epstein, Gates, and trafficking. I did not see that one. That's man. Oh, so he's back out. Okay. So he went to the hospital and he's back out. It was on Real America's Voice. Okay. So that must have literally just happened. So. Yeah, a couple people over here on YouTube are saying they saw it too. So. But, back to the common law here. Again, where there's a right, there has to be a remedy. Like it says here, or not adapted to the object or deficient in the provisions necessary to furnish suitable remedies and punish offenses against the law, the common law. But then they want to say, as modified and changed by the Constitution and statutes of the state, wherein the court having jurisdiction of such civil or criminal cause is held. What? Why are they mentioning criminal when we're talking about common law and rights? That's right, because it can be criminal in nature. We're talking about nature, not as the way that they want to split it up, but the way it's supposed to be. But so long as it's not inconsistent with the Constitution and laws of the United States, shall be extended to and govern the said courts in the trial. So this is in part what I'm going to force the showdown on, is because there are no statutes really. This is all Roman civil law, the code. Right? I'm reading code right now. That's a subversion of law. It subverts the common law. It's a completely different body of law as a fundamental law and part of a form of government. It doesn't belong here at all. You know, it's already been declared to be unlawful in the Declaration of Independence. So, I don't know, this just, triggers my mind when Trump was starting to say that that somebody ought to sue these people, okay? And that's what goes through my mind, is like, okay, I see what they're, under the continuity of government. I'm starting to see it, and what triggered my mind was the New York State Rifle Pistol Association versus Bruin. Okay, and they're doing the constitutionality challenges. And they're striking down legislation. But the reality is even when they're doing that, they're not challenging whether or not Congress or state legislature actually has subject matter jurisdiction. And in a few of these cases that I've been reading, none of them are challenging subject matter jurisdiction. None of them are challenging personal jurisdiction. Well, no man is above the law. Everybody's subject to the law. Sure. What law? Let's lay down the fundamental principles. What's the fundamental law? But see, this is the trickery. The common law is supposed to be the fundamental law here in America, not Roman civil law, the code. And those would be enactments of the legislature. Now let me see if I can pop this sucker up. Well, not on that screen. I'm going to have to pull this up here. Let's see. In Blackstone's Commentaries on the Law of England, which my computer decided to reboot on its own. Some stupid updates. So, where are you? Law books. I believe. I'll have to go back to my screen share here. Some interesting things that I found in here. And this is actually volume 3 and 4, or book 2. And what's interesting here is that this particular page number it's crazy. As to offenses merely against the laws of society, which are only mala prohibita and not mala in se. Huh? The temporal magistrate is also empowered to inflict coercive penalties for such transgressions, and this is by the consent of individuals who, in forming societies, did either tacitly or expressly invest the sovereign power with the right of making laws and enforcing obedience to them when made by exercising upon their non-observance severities adequate to the evil. The lawfulness, therefore, of punishing such criminals is founded upon this principle that the law by which they suffer was made by their own consent. It is a part of the original contract into which they entered when first they engaged in society. It was calculated for and has long contributed to their own security. What's the contract? How about like an oath of office? Because that's how you get bound by alleged statutes, because statutes are for government civil conduct. I know, right? It was a long sentence. But that's the thing, is because mala in se and mala prohibita. Mala prohibita is prohibited conduct. This is where we get into personal jurisdiction. Well, just exactly whose conduct do they have the authority to prohibit? Themselves. Those that are in law. Mala in se is morally wrong, morally evil. This goes back to those 6 primitive laws of nature. In the very first one, when man is properly organized, meaning of sound mind, he knows the difference between moral good and moral evil. So it's like they want to impose alleged statutes, what they call statutory law. Well, that's actually policy and regulations, onto the people that are not mala in se. And to give example of what mala in se is murder. But that comes from the common law. Do we really need the state legislature to make a statute that says murder is unlawful? Or do we have the fundamental concept, common sense law here, common sense, that murder is wrong, that it is evil? And just like any real acts of violence, right? Where we get into like murder, rape, kidnapping, abortion. For those of you who have read the treatise on arrest and false imprisonment, even abortion, that comes from the common law. Now, I get to a certain extent where back in the day, they used to execute people who got abortions because it was considered murder. To this day, we do consider it murder of some sort of degree, or involuntary manslaughter. More stuff made up, shit made up. But say when a car accident, you get in a car accident, and one car has a woman who's pregnant, and she loses the baby. Or if both of them die, right? The mother and the unborn child die, then whoever caused the accident gets charged with double murder, homicide, involuntary manslaughter, whatever, they're held responsible for the death of the child as well. And in any case, it's why is that not being applied equally? How is it that we're allowing businesses, because that's what this really is, right? A business, the doctor's office, whatever, performing abortions. That's what we should be keeping from happening, right? Because that's something we can control, right? And for those of you that think that I'm, anti-abortion, I'm anti-murder. I'm anti-killing of an unborn child. The choice to make was when they had sex to begin with. That was when the choice should have been made, was, either abstinence or use protection. There's many different ways to have, sex out there and not run the risk of getting pregnant. So those are things that's when the choice is to be made, not after the fact. Now, for things such as medical issues that can actually kill the woman, and lose the baby anyway, right? And they both die. Well, then isn't that an exigent circumstance? That's an emergency. But see, you already have a doctor that you're seeing for the pregnancy. So that's already supposed to be a viable option, but that has to be the choice between the mother and the father, right? Or that they may die carrying it out all the way to full term. They may, that's the choice between them. That, in my mind, that's a medical procedure to save life, not as a careless recklessness out there. And oops, I got pregnant, so I'm just going to go ahead and get rid of that. No. Where was I? Just was seeing something about that, the laws of nature here. Where was it? Against the divine laws of nature and become liable. I swear it was something right there. But, we got to, this mala in se really has to do with the laws of nature. And back to those three primary absolute rights. And this is what is talked about right here in Blackstone's commentaries on the law of England, which is where the Supreme Court sent me, in the New York State Rifle Pistol Association versus Bruin case. Okay? And they cited Blackstone's commentaries on the law of England regarding the right to keep and bear arms, which that's in the from the first one here. Volume 1 and Book 1, and I think I have this bookmarked, and it should be And yeah, this is volume 1, book 1. So right here where it talks about the rights of persons considered in their natural capacities are also of two sorts, absolute and relative. Absolute, which are such as appertain and belong to particular men merely as individuals or single persons. Relative, which are incident to them as members of society and standing in various relations to each other. The first, that is, absolute rights, will be the subject of the present chapter. Now, when we're talking about these absolute rights, really, it's the laws of nature. Right here, persons are also divided by the law into either natural persons or artificial. Natural persons are such as the God of nature formed us. But see, God created man. He didn't create persons. And you'll see, from time to time, they switch it up. But they really like to try and get us into that person. And there is no person when we're talking about man. See, even right up here. Oh, yeah. Do from one man or set of men, they must also do to another. See, they know about man, but they want to get into them persons to try to get that personal jurisdiction. But when it talks about these absolute rights, by the absolute rights of individuals, we mean those which are so in their primary and strictest sense, such as would belong to their persons merely in a state of nature, and which every man is entitled to enjoy, whether out of society or in it. Now, what is meant by out of society there is what we're talking about is you're not a member. See, again, back to these crucial words, proper diction. Okay. Member is a member of the legislative branch, executive branch, or judicial branch. Law of Nations, Book 1, Chapter 19, subsection 212 defines a citizen as a member of a civil society who is bound to perform certain duties and is subject to its authority. That's the statutes, as well as the Constitution, right? Because they're supposed to be bound by the Constitution. That's Article 6, Clause 3. And again, Article 6, Clause 3 uses the words members and bound to support this Constitution. They're not bound by the statutes because that's all color of law. It's not law. It's policy or regulations. But see, we've all been led to believe, well, that's the law. No. It's just, it's understanding form of government and the different forms of government. Now, under Roman civil law, under a monarchy, yeah, their code is the law. But when we talk about our republic, the common law is the law. And we all live in the private, in nature. And we're to be left alone. That's independent, right? Free and independent of government, because we're not bound by it. We're not members of that civil society, not in the sense of actual proper diction words, member of the civil society. We live in nature and we're called inhabitants or the people. And that's section 213 of the same. Book 1, chapter 19, subsection 213 defines inhabitants. And, reading in this here was as every man is entitled to enjoy, whether out of society or in it. So clearly there's a very clear distinction between in and out. That would be that outlaw or in law. So suits in law, Article 3. I don't want an Article 3 court. So many people claim they want, well, I want an Article 3 court. Article 3 courts are suits in law under Admiralty and Maritime. That's under Admiralty jurisdiction. No. You want suits at common law, 7th Amendment jurisdiction. Not Article 3. And I've challenged many a people on this, and nobody's been able to provide any proof from Article 3 where it covers common law jurisdiction, with the exception of writs. But that's already from the common law. The common law dictates that. And what we would consider original jurisdiction. But when we're reading the Constitution, that's a delegation of power. It's a creation. So we have to go by what Article 3 specifically states, as it is written. We don't get to import things into it that are not there. That's called interpreting the Constitution. The Constitution is not to be interpreted. It's supposed to be read and followed and supported as it is written. The Constitution is absolute as it is written. We get into here but with regard to the absolute duties which man is bound to perform, considered as a mere individual, it is not to be expected that any human municipal law should at all explain or enforce them. For the end and intent of such laws being only to regulate the behavior of mankind, as they are members of society and stand in various relations to each other, like legislator, whether you're in the House of Representatives or the House of the Senate, or whether you're in the executive branch. That's the various relations to each other as members of a society. They have consequently no concern with any other but social or relative duties. Let a man therefore be ever so abandoned in his principles, or vicious in his practice, provided he keeps his wickedness to himself, does not offend against the rules of public decency, he is out of the reach of human laws. But like it says here, but if he makes his vices public, though they be such as seem principally to affect himself, as drunkenness or the like, they then become, by the bad example they set, of pernicious effects to society. So, when we would say drunk in public, we're talking about a senator comes walking out of the pubs, had a few too many drinks and shooting his mouth off and starts, starts shooting his mouth off and breach of peace, starting threaten people, but it doesn't even have to be that. Just becoming obnoxious, rude, interfering with other people's liberty. Now we got a problem. To a certain extent, okay, the difference between, say, the senator doing that and a free inhabitant, well, the free inhabitant, we can haul him off and just put him in the drunk tank until he sobers up or whatever, somebody can take him home. Senator, no. You're not supposed to do that. That's immoral. Now, you want to get drunk in the privacy of your own home, Mr. Senator? Or let's say you want to get drunk there in the pub. Have a designated driver, call an Uber, call a taxi, and, take yourself home. But don't try to impose human laws, man-made laws, onto the people in the private. See, like it says here, public sobriety is a relative duty and therefore enjoined by our laws. Private sobriety is an absolute duty which, whether it be performed or not, human tribunals can never know. There it is, personal jurisdiction. There's no personal jurisdiction in the private. Only those that are in law, in the public, that are members of the public. And again, we get this confusion about, what it means to be public. And a lot of people, and of course, the courts and everybody else, they will want us to believe that, the second you go outside is the public. And that is false. That's known as the general public, but being in the public, and that's the reason why this is italicized here, where it says public sobriety is a relative duty, and therefore enjoined by our laws. Okay? And right here, what it says, here the circumstances of publication is what alters the nature of the case. Now, would we say that murder is a public offense, or is murder a common law offense? I say common law because it's right in the Ten Commandments, thou shalt not commit murder. And that comes from the common law. We don't need a public statute to tell us that murder is unlawful. And so, essentially, wouldn't that still be a suit at common law because murder comes from the common law? But isn't murder criminal in nature? So how is murder not a suit at common law? Going back to that, legislating for us in all cases whatsoever. And they're supposed to be legislating for themselves, to apply to themselves, to corporations. That contract that are in law, incorporated into the body politic. Now, keep in mind here, we're reading Blackstone's Commentaries on the Law of England. For the principal aim of society is to protect individuals in the enjoyment of those absolute rights, which were vested in them by the immutable laws of nature. It's immutable. It's absolute. But which could not be preserved in peace without that mutual assistance and intercourse which is gained by the institution of friendly and social communities. Hence it follows that the first and primary end of human laws is to maintain and regulate these absolute rights of individuals. Such rights as are social and relative result from and are posterior to the formation of states and societies. So that to maintain and regulate these is clearly a subsequent consideration. But if we already have that body of law, and we go by suits at common law and the rules of the common law, just exactly what do we need government for? And this is the difference between a republic and a monarchy. Of the people, by the people, for the people. It's done by the people. All of it. Our justice of the peace and judges, or should say magistrates, justices, they're supposed to be elected by the people. Of the people, by the people, for the people, not for corporations, not of the corporation, by the corporation, and for the corporation. It's supposed to be for the people. But this is in part what we are returning back to. Okay? Right. Yep. And they like to have their saying in here, oh, but once you join society, you give up these absolute rights. No. The absolute rights of man considered as a free agent endowed with discernment to know good from evil and with power of choosing those measures which appear to him to be most desirable are usually summed up in one general appellation and denominated the natural liberty of mankind. This natural liberty consists properly in a power of acting as one thinks fit, without any restraint or control unless by the law of nature, being a right inherent in us by birth, and one of the gifts of God to man at his creation, when he endued or endowed him with the faculty of free will. But every man, when, this is it right here. Oh, but every man, when he enters into society, gives up a part of his natural liberty as the price of so valuable a purchase. Then it's not absolute if we got to give it up. That's a flat out contradiction to what was just said previously. Now, in the sense of, if we're going to, because I've actually had this conversation with a couple different members of the bar on this topic right here. Well, yeah, but you give up that for the advantages, and I'm like, advantages? Like an emolument, any advantage, profit, or gain received due to one's position of employment or holding of office? Yeah, I don't have that. That's talking about you. Because, see, we the people control your conduct. That's the contract of employment. Yeah, you do give up a little bit of that when you that's the trade-off. And like Chris and I used to talk about, on the clock and off the clock. While you're on the clock, exercising those rights and duties under the emoluments of your office, you have to follow what we dictate. You don't get to think for yourself on that. Again, it's like working at McDonald's. If you're told you're hired, okay, there's the contract of employment, and the boss tells you that, hey, you're cooking fries today, and you decide to go out back and play around on your phone or dink around, do something else, or hey, maybe even let's even pick up a mop and start mopping and cleaning somewhere. Well, it's lunch rush. I need you over here making fries. You don't want to do that. How long are you going to work at McDonald's? See how that applies here? And that's a fundamental principle. When you're elected or appointed or hired into a position of public trust there, whether it's under the legislative, executive, judicial branch, you're supposed to be bound by oath or affirmation to support this Constitution, which subjects you to the laws, the statutes. But it subjects you to the Constitution first because the Constitution dictates certain things for the certain offices. And I like how they put here at this legal obedience, conformity is infinitely more desirable than that wild and savage liberty which is sacrificed to obtain it. For no man that considers a moment would wish to retain the absolute and uncontrolled power of doing whatever he pleases, the consequence of which is that every other man would also have the same power. Well, duh, that's all part of being free and equal and independent. And then there would be no security to individuals in any of the enjoyments of life. Oh, well, I guess that's why we all have the right to keep and bear arms, which shall not be infringed. Oh, how about that first, the primary absolute right? The right of personal security. I get to secure my own life and defend it with arms. See how that works? That would be the good Christian Protestants, the Saxons, that were very adamant about the rights from God, the right of self-defense, the right of personal liberty, the right of conscience, the right to think for ourselves, the right of self-determination. The power of acting as one thinks fit, without any restraint or control, unless by the law of nature, period. Because man is in the private. We're not bound by those particular statutes. But to help even clarify the McDonald's situation. Okay. Personal jurisdiction here. Now, McDonald's has personal jurisdiction over that man because he's an employee or individual of that corporation. Now, does Burger King's policy apply to a McDonald's employee? No, there's no personal jurisdiction there. One, there's no contract. There's no contract of employment with Burger King, only McDonald's. So only McDonald's policy applies to the employee of McDonald's. That's called personal jurisdiction. Then subject matter, we can get into subject matter jurisdiction here, is the contract, right? Well, what were the terms and conditions of employment? Well, if you're supposed to do this, this, and this, and it's enumerated there, and they start asking you to do this, this, and this over here, that's a lack of subject matter jurisdiction because that's not in the contract. For example, let's do the painting contractor with my neighbor, right? I'm going to contract with my neighbor to paint his house, and we come to a general consensus and agreement on what color the body is, what color the trim is, and okay, that's the terms and conditions of the contract. I'm going to paint your house. I'm going to paint the body this color. I'm going to paint your trim this color. Okay, and only that. But can I paint his fence? Can I cut down his tree? Can I take his Corvette for a drive? Can I have sex with his wife? That would be coveting thy neighbor's wife now, wouldn't it? So that would also be lack of subject matter jurisdiction because what the subject of the contract was to paint the body of the house a certain color and to paint the trim of the house a certain color. So it didn't have subject matter jurisdiction over the tree, the shrubs, the Corvette, or his wife. And then that would be an invalid contract. Let's say it was put in there, yeah, I could have sex with your wife. No. That's immoral. Karen. I don't know. Can you? I don't know at this point. I've almost forgotten how. Oh. So we got to keep in mind here, they're definitely trying to hold on uh, to this idea that we give up. On one hand, we're saying that these are absolute, that comes from the laws of nature, but we we have to, we all have to be bound by the statutes. No. I know, right? Karen Grammer. But yeah. Seen lots of new names here on at least out here on YouTube. A couple different ones over here in Telegram. So clearly, there's more people that are joining, and welcome, and glad you're here, folks. Knowledge is power. Now, in part, why I'm kind of covering this again is because last week I talked about doing this civil rights complaint form and flooding the DOJ with complaints. They really need to hear from us. But something I just saw here, I want to continue reading this because this is really, really, really a good section to be reading. Pretty much all of Blackstone's commentaries on the law of England is a very good read. And again, if the Supreme Court is referring to this and citing this as a source of law, a point of authority, we need to be reading this, comprehending this, and citing this in our own paperwork. Right? More desirable than a wild savage would be to retain the absolute uncontrolled power of doing whatever he pleased, the consequence of which is that every other man would also have the same power. Duh. And then there would be no security to individuals in any of the enjoyments of life. Not true. That's a false statement. Right? Political, therefore, or civil liberty, which is that a member of society. See, political rights. Being a member of society is no other than natural liberty so far restrained by human laws and no farther. Now remember, the Constitution is human laws. Constitution's man-made law. As is necessary and expedient for the general advantage of the public. Hence we may collect that the law, which restrains a man from doing mischief to his fellow citizens, though it diminishes the natural, increases the civil liberty of mankind. See how they try, civil liberty. No, it's not civil, it's natural. But civil is Roman civil law, so they got to keep importing that word in there. But that every wanton and costless restraint of the will of the subject, so now we're not talking about man, we're talking about subjects now, see? See how they changed their verbiage in there? Whether practiced by a monarch, a nobility, or a popular assembly, is a degree of tyranny. Oh, good, I'm glad. That was the part I wanted to point out there. So we'll reiterate that. But, so hence we may collect that the law, which restrains a man from doing mischief to his fellow citizens, though it diminishes the natural, increases the civil liberty of mankind, but that every wanton and causeless restraint of the will of the subject, whether practiced by a monarch, a nobility, or a popular assembly, is a degree of tyranny. Nay, that even laws themselves, whether made with or without our consent, if they regulate and constrain our conduct in matters of mere indifference, without any good end in view, are regulations destructive of liberty. Whereas if any public advantage may arise from observing such precepts, the control of our private inclinations in one or two particular points will conduce to preserve our general freedom in others of more importance, by supporting that the state of society which alone can secure our independence. Okay, yeah, here we go. Here's a good one. Thus, the statute of King Edward IV, which forbade the fine gentlemen of those times, under the degree of the Lord, to wear pikes on their shoes, that's spikes, but it's pikes back then, right? Or boots of more than 2 inches in length, was law that savored of oppression, because however ridiculous the fashion then in use might appear, the restraining it by pecuniary penalties could serve no purpose of common utility. But the statute of King Charles II, which prescribes a thing seemingly indifferent, a dress for the dead who are all ordered to be buried in woolen, is a law consistent with public liberty. For it encourages the staple trade, on which, in great measure, depends the universal good of the nation. So that laws, when prudently framed, are by no means subversive, but rather introductive of liberty. Basically, this is where we get into bills of attainder and bills of pains and penalties. That right there, the not prohibiting the wearing of spikes on their shoes and boots of more than 2 inches long. That's a perfect example of a bill of pains and penalty. I can wear whatever the hell I want to wear. Even if some find it offensive. Whew. Brother Rob, how you doing? You got a big old post here. I'm trying to read that real quick. I wonder where your source is for that. That would be an interesting read, but and so this is is it Algernon Sydney? But Hmm. Oh, so Missouri just passes a bill to treat gold and silver as legal tender. Imagine that. Well, good job, Missouri, but it's already in the Constitution that says that. Ah, I hear on Rumble. What does that say? Tinted bits. Destry was on his Hardlines podcast last night and gave me kudos on my deep dives and research. Well, thank you, brother Destry out there, and thanks for the info there. You know, reading means reading, guys. And this is the way I've gained my knowledge, is by reading. And, you know, how am I going to present any of this in any kind of a court case if I don't know it? Yeah, Mark, it's coming. Mark's comment out here on YouTube: I still can't find any banks to take gold or silver. I have not found any that will. Well, we still already have silver coins. There's a certain amount of silver in that coin. Right? Over here on Telegram, turning rights into privileges once again. You know, that's been the test of time. That's that civil rights. They want to claim that they're actually privileges. And this is one thing that, you know, Blackstone's commentaries on the law of England is exposing. I mean, how is it that on one hand we recognize the laws of nature and that man is creations of God and gifts, and these rights are gifts of God to man at his creation? Well, then, how do we sit here and say that they're not? That they're not natural rights? It comes from the laws of nature as a body of law. Like Roman civil law, the laws of nature, it's two different bodies of law. If it wasn't, then how's it being written right here and being read from if it's not a body of law? But this is part of that lex non scripta, the unwritten law, because this is supposed to be so common law, common sense law, and like the Declaration of Independence says, this is supposed to be self-evident. Plain and simple. We should naturally we should know this. Like instinctually. I mean, at any time you have any man, it doesn't matter what disguise he is wearing, comes up to you and says, hey, you, stop. Who the hell are you to tell me to stop? You mind your own damn business and I mind my own. Got some ID? Kick rocks, dude. Period. That's depriving me of my liberty, my personal liberty. Now, if you got a cause of action, well, now that's a different story. But it would have to be in the middle of the action. But as you can see, somebody has been seriously highlighting, these particular sections for good reason. Like here, so that laws, when prudently framed, are by no means subversive, but rather introductive of liberty. Ha! The thing is again, do we really need some sort of a statute that says murder is unlawful? How about stealing? How about lying? I mean, if we've gone so far away from common sense that we need to have the legislature legislate for us in all cases whatsoever? No, we don't. It's not. The reality here is, what did we actually grant of a power of government? To defend our rights. Plain and simple. That's the primary intent of instituting or creating government, was to secure our rights from infringement and to set down processes and, due process of law. And that we elect our public servants to serve the people, to defend the people, and not to make legislation that would infringe on any of our rights. Because we didn't give them power over our rights. Well, Warhorse for Liberty out here. Do I know how to find county court surety bonds for judges? Or at this point, are they hiding it so well, we have to do a FOIA request to obtain that information? Okay, I'm going to remind people, insurance bonds, surety bonds, whatever. They're there for accidents. It doesn't cover willful misconduct. So this whole concept and idea about bonds for the win and all that stuff, absolutely zero success in going after their bonds, I can guarantee you. None. Zero. Well, and I did some research in the Idaho Code on the bonding type stuff. And some corporations will have a blanket bond that covers all of their employees. Okay? Some members or certain individuals may carry their own individual bond, but again, it's all for accidents, not stuff done on purpose. Doesn't cover criminal behavior. So, technically speaking, you can't go after their bonds unless there was some sort of a mistaken accident, right? That it wasn't done willfully. I mean, Think about it. Two people get in a car accident. Why do they always want to find who is at fault? Because the one that is not at fault pays, right? Now, let's say a bank robber goes in and robs a bank, comes out, jumps in a car, and crashes and runs into things. Does the insurance company cover that? Nope. Nope. They will not cover criminal conduct. Be hard pressed to get insurance to cover that. Now, this may be where your own insurance may come in. Especially if you've got full coverage insurance. But if you have like the crappy basic liability where it covers if you're liable. I mean, that's why they call it an accident, right? Oh, shit, yeah, I ran the red light and I ran into somebody. That was an accident. A traffic accident. That's why they call them accidents. It wasn't done on purpose. But they want to find who is at fault. Got to have that who is at fault. Yeah. Don't waste your time on trying to pretend like you're going to be able to go after their bonds. Okay? Learn how to do the proper paperwork and sue the crap out of them. That's where it's at. You know, my educational series. If you want more than what's in my educational series and you want to get in on my Wednesday night workshop, that's Wednesday nights through Patreon. It's a private class, okay? That's where I'm teaching the more hardcore stuff, okay? The little intricacies and how to do the paperwork and what it looks like. And I want to remind people, Executive Order 13818, blocking the property of those involved in serious human rights abuse and corruption. We need to tell on them. It's as simple as that. The gig is up, guys. The shenanigans are over. It's just a matter of the people standing up and telling on them. Got to have that cause of action. And while, yes, I get that there are plenty of people out there that have evidence on a lot of these guys, okay? Great. Some of them are being taken out. Some have already been taken out. But this is what I keep trying to tell people is on a local level, what is happening directly in front of us? You know, your local police officer, your sheriff, your judge, so-called judge. Okay? The county prosecutor, city prosecutor. That's what I'm trying to aim at. That's what we need to report on. That's what we need to go after. What is directly in front of us that's happening directly to us? That is what we need to redress or address. Okay? Yep. So hopefully, hopefully people tune into this when I'm going to put it out there, and it's going to be basically a special event, special video going over this. And like I said, I've got these civil rights complaint form here, and this one's for the District of Idaho. This goes to the United States Attorney's Office. See, again, executive branch. And well, I'll have to pull it up online and show people how to go find this, and do these online. I think I actually had somebody hand me a stack of them, and so I've had these for a while, and I'm thinking, not really exactly what I want to do, but I think this is somewhat simple enough. It's not a Title 42 1983. This is basically just doing a civil rights complaint form to get them to investigate. But it does ask, have you filed a lawsuit concerning this matter? Have you filed a complaint about this matter with any other federal, state, or government agency? So, well, again, technically speaking, none of them have a legitimate oath of office. Okay, that's that. People, you're trying to pick on things that have no real relevance. Start focusing on what the actions are that they have taken, that they are taking or have taken against us that violate our rights. Cut out all this fluffy stuff. Get down to the nitty-gritty and do just that. What is the right? What is the conduct that violates the right? And what are the actual damages? Let's keep it simple, folks. Okay? Real simple. Forget their oaths, forget their bonds, forget all that other garbage. Right? And focus on the actual conduct that violated the right. Keep it simple. You're, spinning your wheels in the mud. Pay attention. I'm going to reiterate that again. What is the right? What is the conduct that violated the right? And the actual damages. The who did what, where, and when. That's the 4 W's. And it has to be a very short, very clear, and concise statement of fact of what they did. Don't say, oh, they violated my right. No. That doesn't tell me what they did. Again, read the treatise on arrest and false imprisonment. Read the statements of facts in that complaint form. There's a document template right in the treatise on arrest and false imprisonment. Stop trying to make this more difficult. Keep it simple. That's the old acronym KISS. Keep it simple, stupid. Keep it so simple it's stupid simple. And that's what we need, right? And that's what this is, right? You know, that's what it's asking me here on this complaint form, you know. Person's filing complaint. Person, entity you are filing complaint about. What is the name of the person or entity? What's the address? Blah, 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 blah. Nature of alleged civil rights violations. Please check specific areas that apply to your complaint. You got abortion clinic access, credit lending opportunities, disability rights or access, educational opportunities, employment discrimination. I don't even get this one. Hate crime, housing discrimination, human trafficking, law enforcement misconduct. There we go. There we go. Military veteran status, prisoner or institutionalized person's rights, race, national origin, religious liberties, voting rights, or other. Okay. Employment includes immigration-related unfair employment practices. Please clearly describe the violation of the civil rights laws that you would like to bring to our attention. Include as much information as possible, including the date, the place, nature of incident, and contact information for any witnesses. Please include copies of supporting documentation, but do not send original documents. Do you believe that the violation of civil rights described in this complaint is part of or results from a policy, pattern, or practice on the part of the person or entity named above? If so, please describe the policy, pattern, or practice in detail and identify others who you believe were subjected to the same or similar treatment. Are you represented by an attorney in this matter? Have you filed a lawsuit? Have you filed a complaint? And that's it. That's how simple this is, guys. So, this is what again, where I'm at is trying to figure out how to tell on these people about the easiest way possible. And given that one executive order that Congress did do something with it, morphed it in under the DOJ, which is the fraud, waste executive order, creating that new task force. But again, squeaky wheel gets the grease. And here's the thing, folks, is it's the same everywhere. The statement of facts. Once you do the statement of facts of who did what, where, and when, the 4 W's, that's your affidavit portion of any document. Once you do the statement of facts of who did what, when, and where, that can be used and attached to any other document. Could be a criminal complaint, could be a civil complaint out of 42-1983, could be in the petition to the legislature, because the statement of facts of who did what, where, and when never changes. It's always the same facts. So, again, people need to do the statement of facts. You have to tell the story in very short, clear, and concise statements of facts of who did what, where, and when. Again, what is the right? What is the conduct that violated the right? What is it that they actually did? Their conduct. There is no other way to do this. None. This is at the root of anything and everything that anybody would ever do, is that statement of facts of who did what, where, and when. It doesn't matter where you're going to go with it, whether it's the legislative branch, executive branch, or judicial branch. You're going to have the statement of facts. Plain and simple. There's no ifs, ands, or buts. There's no other way around it. Okay? So, if you haven't done that, don't be worried about looking for their bonds. Don't be worried about looking for their oaths of office. Because you need to focus on the primary things first before you look at anything else. Okay, you're talking about a case, okay? You got to continue on. Have you done a petition to the legislature for the redress of grievances in proper form? Have you filed your appeal? Have you filed your own Title 42, 1983? Okay, things have to be done in a particular order, and like in traffic, so-called traffic cases and that kind of stuff. Okay. When you go through that process, just like I did all the way through trial, I had to conduct my own trials, 2 of them. Okay. Now it's on appeal. Now it's my turn. But I have to create the record, and that's why I did the way I do and what I teach. In a way, it entraps them because they have to respond in writing. So for me, what I'm doing is I'm gathering evidence. I'm giving them notice. I'm affording them the opportunity to do the right thing. And when they respond back with their psychobabble, shit made up by the bar, the Roman civil law, the code, now I can go after them. And I can go after the stuff they're citing and take that down. Okay? I'm on almost 2 years in my case just to get through trial. And, we've talked about this before. The wheels of justice move really slow. It's just, it's again, right? It's the long game, right? If you're expecting a quick fix overnight, I don't know of anybody out there that has that. Now, the other thing that can be done is lawful notification letters, right? I have had certain occurrences where it's never turned into a court case just by simply talking to them or doing a lawful notification letter. It never turned into a court case because they backed off after I served them with a lawful notification letter. They're done. Yep, we're done. They don't want to go there with me because I already put them on notice and afforded them the opportunity to do the right thing. That's just how that works. And in my experience, it does work that way. Now, in my particular case, I didn't necessarily do the lawful notification letter route because I wanted to gather the whole thing, including the trial by jury and how they're depriving the fundamental right of trial by jury. Right? I have to let them commit the crime in order to gather the evidence against them that they are depriving that fundamental right. Because it's like, you can't arrest a bank robber when he hasn't robbed the bank. Where's your evidence that he robbed the bank? Well, he was thinking about it. That's no. Doesn't work that way. Ah, Dave Cantera. Good to see you, brother, over here on Telegram. Started talking about me on Twitter on specific X spaces and that deal with what to do on election integrity. Yeah, election petition. I've tried. I beat that sucker to death out there, and I even handed Kerry Lake paperwork directly right out of Lex Parliamentary Americana. What it says, the Arizona Constitution. Nothing. But thank you for passing that on and bringing people this way, Dave. I greatly appreciate it. Knowledge is power, right? It's just a matter of taking the action, doing the paperwork, and taking the action. And it's quite interesting how that lays that out, how it talks about doing the election petition, filing that into the legislative branch, and being the only branch of government that has the authority over election. How it talks about they have to bring the ballots, literally bring the ballots in there. And they have to visually inspect them and all that good stuff. And verify that they're all legitimate ballots. Bring in like the voter rolls. Scrutinize the voter rolls. That would be a good start right there. Scrutinize the voter rolls. Well, are all these people still alive? Let's get some raw numbers here of the real numbers of how many people are actually, I know a lot of people don't like this, but registered voters in the district. Because you can't exceed that number, right? Then you've got the part of how many people actually vote. But that's a good start, the number of registered voters and checking the voter rolls to begin with. And start eliminating people that are still on the voter rolls that are deceased. They're no longer among the living. And then you got people that have moved, but still on the voter rolls. And yeah. Yeah, see, Karen, the problem is David Jose talks about going to the judicial branch. The law dictates we go to the legislative branch. Separation of powers doctrine. Power proper belonging to one branch cannot be exercised by another branch of government. Again, that's this book right here. Lex Parliamentary Americana, Elements of the Law and Practice of the Legislative Assemblies of the United States of America. This is the law. Because that's common law. Again, so many people do not comprehend that there's a common law side to our republic. It comes before the Constitution. Again, body of law, common law. Reading means reading. But, right? No, that's not where he says to go. That's in your own comment there. Support of her for judge. For judge, right? That was in the judicial branch, not the legislative branch. But, the other thing is, like David Jose talks about just affidavits. He doesn't know the proper form of a petition or any of that stuff. He doesn't do any of that stuff. And affidavits do not stand by themselves. You have to, they're supposed to be attached to something. Yep. In support of. Yep. Yep. Affidavits are supposed to be in support of. Hey, Bob Schuler over there on Facebook. Go to my website, kirkslawcorner.com, and download it. It's in my library. Let me see. Let's see what we got here. We can go do that. Go to my website here, kirkslawcorner.com. Library tab. After you get done reading all of this other stuff first, which I highly recommend. No. Right here. Lex Parliamentary Americana. Elements of the law and practice of the legislative assemblies in the United States of America. Luther Stearns Cushion. Okay? JG, good to see ya. An affidavit is in support of a complaint or a motion. The statement of facts is the actual claim. I claim you did this. I claim you did that over here on this day. So, there it is right here. Bob Schuler, brother. Right there. Now, here's the 2010 Mason's Manual Legislative Procedure. That's this one. This black one here. This is how I discovered cushions, because on damn near on every single page in this 2010 edition references cushions. So I'm like, yeah, I think I need to go find that. Again, that's the rabbit hole. That's how you do how I do research, and how members of the bar are taught to do research. You know, you'll read this book here and you look at all their sources, just like reading a case, like New York State Rifle Pistol Association versus Bruin, when they cited Blackstone's commentaries on the of England, section blah 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 blah. What do you think I did? I went and looked Blackstone's commentaries, Law of England, looked up that particular section, and where did it take me? It took me right there to that first primary absolute right of personal security and the right of self-defense from the laws of nature. Yeah, that's a good one. How do we find Cook's writings? I actually did a search on Archive. That's a tough one to find it. My brother Rob, I don't know, he seems to have some fairly good luck on there finding stuff, so I'll have to get with him one of these days and all of his findings. But yeah, there's all sorts of good stuff on my website here in the library tab. And for those of you that may be new here tonight, up here in the upper left-hand corner here, there's my Facebook page, my Telegram channel. This one's the P for Patreon. There's YouTube channel, Rumble channel, and X. We're live right now on all 5 channels: Facebook, Rumble, or Facebook, Telegram, YouTube, Rumble, and X. We're live right now on all 5. If you don't like that, there's a links tab. This will get you to my Patreon as well. This gets you to the Rumble channel. This gets you to the YouTube channel, Facebook channel, Telegram channel, and Twitter, now X. Okay? And again, for those that want to help support me here, doing what I'm doing for free every Monday night, plus the don't forget the free educational series there on YouTube. Go into that playlist. Um, here's the address to send your donations to if you'd like to send a donation to the office. Good old snail mail. Oh, come on. 6477 West Fairview Avenue, Suite G, Boise, Idaho, 83704. And Suite G is in golf. Move it on up. Moved up to upstairs. So, I want to thank those that have previously donated. Otherwise, you can do a basic subscription on Patreon, Tier 1 for $5 a month, Tier 2 for $10 a month, or whatever you choose. You don't even have to select a tier. You can just say, I want to give you $15 a month, donate $15 a month, whatever you want. Okay? Yeah, I was wondering about that book, Brother Rob. Still got that book rolling around in your with you in your truck, huh? Yep. I need to get that on here. Blackstone's commentaries on the law of England, but archive.org, folks. I've got two mismatching files for Blackstone's. Archive.org. Right here. Put in there whatever it is you're looking for, you know. Blackstone's commentaries on the law of England. Click on go. What? One? See what I'm talking about sometimes? Now, I've already been on here before, and there was a crap ton of them on here, and I had to go through a whole bunch of them. Now, all of a sudden, it's what? Just one? One result. Weird. Yeah, that's weird. And that doesn't say published in 1865. I wonder if that's all of them. All in one. Nope, it's not. Only 781 pages. Or it might be. I notice he talks about Bouvet's Law Dictionary, adopted to the Constitution and laws of the United States of America and of the several states, John Bouvet. From Joseph Story, imagine that. But this is probably just going to be Yep, this is volume 2, books 3 and 4. It's not volume 1, books 1 and 2. So it's weird how it's only come up with 1. But I could just try doing commentaries on the law of England and see what comes up. See, there's a whole bunch of them now. Good luck. That's how you do that. Look at all these choices you got to go through and try and find. Blackstone one. Right down there, you'll see William Blackstone, by William Blackstone. And then you'll want to make sure that you get ones that match. But yeah, fun stuff. So that's a very good website. Archive.org. As well as, just so everybody is aware, this is where you get back to the Wayback Machine too. I mean, you can type it in too, but right here in the Wayback Machine, you can go right here. You can open that up. So, without further ado, we'll call that a night, and hope everybody enjoyed tonight's Monday Night Law. Maybe learned a couple things, maybe. And hopefully we'll see you folks over there Wednesday night for Wednesday night workshop. Thursday night on the National Assembly call. All right. And then see you back here Monday night, next Monday. Y'all have a wonderful week, and we'll catch you on the flip side, all right? God bless. God